Have given due consideration to the application and submissions of counsel for the applicant and for the respondents. By a majority of 8-1, this court disallows this application. Costs shall be in the cause. The detailed reasons for the ruling will be contained in the detailed judgment.
National Unity Platform Party President Robert Kyagulanyi, through his legal team led by Medard Lubega Segona, spent the better part of the day laboring to convince the 9 justices of the Supreme Court to allow them file more evidence out of the earlier set time given by the Chief Justice Alfonse Owiny Dollo.
It was an application, my lord, for extension of time, and that is what we are here for.
The lawyers argued that they failed to beat the deadline to file all the evidence because security had earlier held their client Kyagulanyi at his home, whereas the NUP party offices at Kamocha in Kampala were also sealed off by security officers immediately after the general elections.
With respect to prejudice, I agree. There will be some inconvenience to counsel for the first respondent and to the parties across the side. But that's not the prejudice that the law is talking about. Prejudice relates to inability. Now, some extra strain is acceptable. Just like I'm going through some extra strain because of the, I don't want to say the conduct of the Attorney General, but people serving the Attorney General. There is uncontroverted evidence, my lords, before this Honorable Court. One, that the officers of the Attorney General have misconducted themselves to the extent of disabling this process. I have talked about abductions. Abductions by their own nature are illegal. The Attorney General has not learned from the previous decision of the High Court that his conduct was illegal. And I'm referring to his with immense respect. I'm not referring to the person of Honorable Biaruhanga. His people have disabled. For example, there is evidence on this record that his officers only vacated the petitioner's, the applicant's office on the very last day court had granted for filing evidence, in the evening when there is no more time.
However, Kyagulanyi's claims were rebuffed by the lawyers of the 3 respondents, the Attorney General, President Museveni, and the Electoral Commission. The lawyers argued that Kyagulanyi's application was ill-intentioned and meant to delay the delivery of justice in this petition. They claimed that Kyagulanyi realized that he does not have a strong case upon which to cause the nullification of the results of the 14th January 2021 presidential election.
My Lords, Counsel Segona on the same record is quoted as having said that they were going to be more prepared going forward. My Lords, what we are seeing now is the exact opposite of that. As this court noted, not only did they fail to serve the 50 or so affidavits on the 11th, but even when time was enlarged, my Lord, the record is clear that this court gave them an additional 4 days. The court noted that they had 10 days, and the court noted that they're giving them an additional 4 days. Even then, my Lords, the filing was on the very last dot of 5 p.m.
Petition, they've had 15 days to file affidavits. They have 3 days to file their answer. They've been given 33 days. That's more than 50% of the time. The respondents, on the other hand, have been given 6-7 days to respond to the first 50 affidavits. My Lord, it's been an odious task, and we are still struggling with it. Unfortunately for us, we dare not ask you for more time because even this day has been lost. My Lord, the politeness of court may be misused and misunderstood. When the court speaks to us, they are orders. They may seem like suggestions, but they are orders, and they must be followed.
After the ruling, NUP lead lawyer Medard Lubega Segona said he would report back to his client Kyagulanyi for the next instructions.
But we have not come to the conclusion that the case is failing because of that. Although I must confess that every evidence, every piece of evidence you want to bring to court is important and impacts on the case.
This is the second time Kyagulanyi suffers a defeat in court on preliminary applications, the first being when the Supreme Court rejected the application to amend the petition and file fresh evidence and the grounds of the petition. Raymond Tamale, NTV.